everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So unfortunately, the Nguyen v. Bonta challenge to California's 1 in 30 law, one of the most unconstitutional laws in the state of California, which amounts to nothing more than rights rationing, is not quite over yet. As a matter of fact, we have a very important date that is coming up just tomorrow, as a matter of fact, that we need to talk about. So if you're somebody who enjoys getting more than one transfer per month, you definitely want to pay attention to this one. So let's get to it. Now, real quick before we get started, this video is proudly sponsored by Jaeger Mount, which is a next generation, durable, modular, made in the USA mounting solution for your gear and tools. Now, unlike flimsy pegboards that have hooks and loops and nothing really fits quite right, Jaeger Mount is a modular solution that will hold your tools secure. You can either slide things in or pop things on. They even mount to existing pegboards to give them that extra rigidity and extra modularity. You can stack them up, you can build them up wide, put your Jaeger Mount panels however you see fit. Now, I chose to put some tools of the trade on my Jaeger Mount, including that hammer and that very heavy blue sight pusher, which probably weighs close to 10 pounds. But you can put whatever you want: screwdrivers, sockets, socket wrenches, pliers, just about anything will go on this mount. They even have these buckets right here where you can put your small parts and pieces, nuts, bolts, things like that. So check out the link down below to Jaeger Mount and support a US company. These guys are doing really good work over there. Thank you to Jaeger Mount for sponsoring this video.
I want to make sure I understand your answer. Is your answer that no, the state of California's position is not that the Second Amendment is satisfied so long as you can possess one firearm?
So the Second Amendment right is encompassed in the fact that the arms is plural. So other courts have said that that means that you can possess more than one firearm, but that doesn't mean that you can acquire more than one firearm at a time.
What?
Okay, so let's go ahead and talk about what's going on here. So again, we're talking about the FPC case called Nguyen v. Bonta. This is the case that challenges California's 1 in 30 law. It's basically a law that says you're only allowed one firearm transfer every 30 days. It is rights rationing. It is completely unconstitutional. As a matter of fact, it was even found unconstitutional by Judge Carney at the district court level. Now, after he found that it was unconstitutional, unfortunately, the Ninth Circuit stayed the injunction that he placed upon its enforcement. Now, that stay was eventually overturned, and it was recently heard by a 3-judge panel where, again, the 3-judge panel of the Ninth Circuit Court of Appeals found unanimously that California was violating people's Second Amendment rights with their 1 in 30 law. Well, as you all know, the California Department of Justice has absolutely no problem fighting to uphold California's clearly unconstitutional laws, and it's almost always under the guise of safety. That's how a vast majority of these laws are created, through the lens of safety. But in reality, it's all about infringing on your rights, and it's all about having control. So California obviously still has another option. After the 3-judge panel unanimously found that California's law was unconstitutional, they could still appeal en banc. Well, we waited to see what the California Department of Justice was going to do. Are they going to appeal en banc? Typically, they have these appeals ready to go so that they can do it same day, next day, or within the first week, and we didn't see anything like that. What we ended up seeing was a request for an extension to appeal en banc. Now, for those of you who don't know what en banc means, it's kind of a strange word. In most circuit courts, it means that every judge from that court will actually take the bench and rehear that case. In the instance of the Ninth Circuit, however, because it is so huge and it covers such a big area from Alaska to Nevada, Arizona, California, Oregon, Washington, Idaho, Montana, it's so big that they can't actually get all of the judges together. So in the Ninth Circuit's instance, a vast majority of the Ninth Circuit judges will again rehear the case, and that's what California filed an extension for. Now, that extension is up tomorrow on August 6th. So California has until the end of the day tomorrow to file that petition en banc. It is surprising to me that they have not done that yet. And if they don't do it, that means that the 3-judge panel's decision stands, and that is it. It is final. Now, unfortunately, the California DOJ and the Ninth Circuit are known for using delay tactics. things that would extend cases out far beyond where they should ever be. In some instances, we have cases out there that are hitting near a decade before we get final resolution. And so that could be part of the plan that California is rolling out here. They are waiting till the final moment to file their petition en banc. I'm not sure exactly what would benefit them from doing that, because as of right now, the law is not enforceable. And so people are able to get as many as they want, as much as they want, without having to worry about the 1 in 30 law. Now, there is another bill that is making its way through California that is looking to change it from 1 in 30 to 3 in 30. So maybe they're trying to kind of parse that out, but I don't know exactly what the benefit would be for waiting this amount of time, given the fact that people are enjoying a little bit more freedom in California as it stands right now. But we'll see what happens. Now it's kind of a waiting game. We're going to wait to see if California actually does decide to ask the court for an en banc review. Now, I want you to keep one very important thing in mind as the end of the day tomorrow approaches, and that is that the Ninth Circuit doesn't have to accept California's request for a review en banc. They could look at the 3-judge panel and say, we agree with their decision, nobody really wants to take on this matter, and so we're just going to allow it to stand. That is another possibility. And if they do decide to take it, they have to contend with the fact that that 3-judge panel said, not only does this law, the 1 in 30 law, not have a historic twin from the founding era, but it doesn't even have a historic cousin. There is nothing comparable in our nation's history and tradition of firearm regulation that could be used to uphold the law as it stands today. And so again, they're going to have to contend with that, and I don't think there's any way around it. This is unconstitutional. It's basically stopping somebody from, or preventing somebody from practicing their right for a 30-day period. It's unconstitutional. Anyway, I wanted to share that with you as tomorrow comes around. Y'all have a great day.